I'm here with Bruce Macewen, who is the founder and president of Adam Smith, one of the most prolific and most read observers of the legal marketplace. And let's start by talking about the current state of affairs of the largest law firms, the Am Law 200.
Okay.
Just share with us, if you would, your sense of how they are doing.
So, I'm an economist by training, as you probably know. Adam Smith was, the most famous economist in the world, in my opinion, the father of capitalism, my intellectual hero. So I tend to think of the world in terms of markets and the dynamism that comes with markets. So big law, as I call it, law land, is at a fascinating point. And I've spent my career in this industry one way or another, practicing, being in-house, Adam Smith. There is, for the first time, really emerging mark segmentation in the market. So there's this tranche of super elite firms, we all know who they are, that is pulling away from the rest of the market in terms of financial performance on any measure you care to name, to the point where I think that the gap between them and the rest of the market is unbridgeable for all practical purposes. They have the name brands, they have the cachet, they're the go-to firms. And for them, it's a virtuous circle. They attract better talent attracts better clients, attracts higher rates, etc. They're fine. They're just going to be great as far as the eye can see.
So that makes perfect sense, and including the idea that it's a virtuous cycle. And so on what's an order of magnitude of how many such firms there are? I'm not sure we all do know who they are, and many people probably think they are and they're not, but how many
Second that.
Would you say are
20.
Okay, so 20 or so in that category. So that's one segment.
Mm-hmm.
All right.
And then there is, by and large, everybody else. These are firms that may be delusional about who their peer set is at the sort of top of the ladder. But most firms actually are not delusional about who their peer set is, and they are, like it or not, kind of middle market firms doing a little bit of work that is very high level and a lot of work that is execution. So it's things where the client knows they need something done, they want to do a transaction, they need to defend a case, etc. And the law firm has to go out and put bodies on the ground and get it done. But frankly, and I know because I've asked the managing partners of a lot of these firms, virtually none of them have any distinction. They're fungible. What makes your firm different? It's our culture. Well, yeah, great. Clients care about culture.
So let's talk about how the market might be able to distinguish the firms. You've shared with us how the firms might distinguish themselves. How does the market distinguish among, and let's take for our example that we're talking about 200 firms. We've now designated 180 in this second category. How does the market distinguish among them?
Some actually have functionally different business models. There are those with a global footprint. There are those that are regional leaders, although I think in this day and age of globalization, regions are increasingly irrelevant. Some are boutiques in a particular area, and these are the exceptions to the great fungible mass of firms. There are firms that are litigation boutiques, that are IP boutiques, that are labor and employment boutiques. Clients get that. If you need office supplies, where are you going to go? You're going to go to Staples or Office Depot, right? I mean, you get it. It has value to the client. It's an identity for the firm. But the general practice, sort of national destination for nothing in particular firm, they're in a perilous category. Now, if you're asking me why they haven't changed yet,
I haven't come to that yet. But that's a good question. Let's answer that one.
The industry is in a period, it's been a sustained period, but it's still there, of what economists call supernormal profits. They're making a lot of money because of particular historic structural barriers, all of which, in my opinion, are crumbling.
So let's identify one or two of those barriers that you think are crumbling.
Access to legal knowledge used to be scarce. It's not. I mean, Econ 101 would tell you scarcity drives up price. There is no such thing as scarcity anymore of legal knowledge per se. It's on the net. Or, frankly, there's no longer any scarcity of executional capability. You don't have to go to an Am Law 200 firm to find an excellent litigator, to find an excellent corporate lawyer. And a lot of the non-Am Law 200 firms' rates are kinder and gentler. The second leg of what's changing, scarcity's gone away. Clients are much more sophisticated and discerning about their law firms than they ever have been. In every previous recession, clients got religion about rates, beat the rates down, and then when the economy recovered, it turned out they were bluffing. This time they are not bluffing. They are undergoing structural changes, bringing more work in-house, looking at the legal process outsourcing community. And when I talk with law firms, often it's very clear they feel, as I mentioned earlier, no pressure to change. That's the wrong way to think about markets. Yours is not the last vote. As the military says, the minute you enter battle, the enemy gets a vote. Well, the market gets a vote, guys. And clients and the legal process outsourcers are changing the dynamic. I think it's actually proceeding under the surface a lot faster than the industry average generalized statistics reveal.
That's a very interesting observation. The skeptics would disagree with you. They say that this time isn't different and that the buying patterns of the clients will return to normal. Why are they wrong?
At the top end, they're absolutely right. Everywhere else, I think they are wrong if you just look at business history over the last 40 years. I mean, every corporate function, finance, HR, IT, marketing, God knows, manufacturing, distribution, has been, right-sized, Kaizen, Six Sigma, re-engineered, except the law department. The game is up. This is coming to the law department. And general counsels of the most sophisticated Fortune 100 firms will tell you that. And the reason I say this is probably proceeding faster than it looks, if a Fortune 100 decides they're not going to use one of these undifferentiated law firms anymore for things that they could do elsewhere, they're not even going to tell the law firm. They're just going to stop calling.
Right. This is a very important observation. The data we have tells us what it tells us, and we don't have accurate data on the movement of the market from one segment to another. It's just not, that score isn't kept yet. So let's turn to the future and talk about what the model of the law firm is going to look like. You and I have written a pair of posts together, two pair, on the Legal Executive Institute about what that future law firm model will look like. And you were very clear that that model, the right model, is not a general partnership. Why not?
It gives partners a mistaken sense that they're actually owners. And in the column I wrote, I said, this calls for people to distinguish between fact and truth. It is a legal fact that, yes, in a general partnership, they're owners. That's what a partnership is, Common Law 101. But that's not actually the truth of any of these large multi-jurisdiction organizations we have going today. The partner's ownership interest is maybe a loosely enforceable claim on current earnings. They have no equity, actually, in anything. They have no ongoing ownership interest, but they think that they are all kings and dukes and princes of the place, and that they ought to be able to call up the managing partner and get their way. One law firm we know revamped its website, its stationery, its business cards, and a partner said, "I like the old business cards, I'm sticking with them." This is insanity, but that's the way they think. I am suggesting that while, yes, in a strict sense, the organizational form is not going to determine your success or failure in the market, this is a psychological and structural impediment that the profession needs to get past.
Right, so let's talk about that. So it's an impediment to what, and in what way is it an impediment?
It's an impediment to teamwork. It's an impediment to thinking about the firm first. It's an impediment to thinking about behaving like a one-firm firm. And it's an impediment to organizational discipline. Law firms, too many of them behave like hotels for lawyers. You know, we'll rent you a room or a floor, and you can do whatever you want, you know. And that is not an enterprise that is going to be durable. There are two dimensions in which law firms, which are critical to law firm organization. One is the short-term versus long-term, consumption versus investment dimension. Partnership is all about immediate consumption. I want every nickel of the balance sheet paid out at the end of the year. The other dimension is what I call collaborative versus carnivorous. So are we in this together? Are we trying to build something? Is there a future for the, poor associates and junior partners coming along? Or is this, every man and woman for themselves kind of place? Now, those are choices, but choices, as always in life, have consequences.
And so what model then would you propose for law firms of the future?
A general C corporation.
And how will that be better? So you've been clear about the distinctions that might derive from one model or another. Why will the corporate model be better?
One of the primary changes that would come inherent in that model is the ability to give equity, real equity, in an ongoing enterprise to non-lawyers. And that's very important. Actually, parenthetically, I think the phrase non-lawyer should be banned. But the finance people, the IT people, the marketing, the researchers, the personnel, all the people that in any normal corporation not only have a seat at the table, but have a real voice. I mean, incredibly sophisticated corporations. Procter & Gamble is run by marketers. And lawyers need to shut up about the business, which they know nothing about, do the highest and best thing they can do, which is practice law, and let the business professionals run the business. All right.
Well, thank you very much for taking this time, Bruce. This was fun.
Absolutely. Thanks, Ralph. Always good to see you.